Hi, I'm Will Hughes, and this is episode 3 in the basic introduction to construction contract law. Today I'm going to be looking at contract formation and operation. So the focus today is on how contracts are formed. I'm going to be dealing with two main questions. First, what does it mean to have a contract? And second, how does a contract come into existence? So a contract is like a promise. But it's different to a promise because it usually involves undertaking to do something in return for someone else, for something else. In other words, it is an agreement between two parties. But does that mean that if we agree to go out for a meal tonight, that we've got a contract? Well, not necessarily in legal terms, no. There's more to contract than simply an agreement, because if one party does not do what was agreed, then the other party can take legal action against them through the courts. Therefore, the definition of a contract for our purposes is that it is an enforceable agreement. So, the formation of contract. How is a contract actually made? The reason that this is an interesting question is because when contractual relationships fail, when one party wants to accuse the other one of not keeping their part of the bargain and they go to court, then the courts will try to decide whether or not a contract had come into existence. And they look for a series of things. Things like offer and acceptance, an intention to be legally bound, consideration, which is the idea of value being transferred from one party to another party. This idea of consideration stems from the idea that the promises or obligations that we're talking about in contract must be part of a bargain between the parties, and the parties show that they've bought the promise of the other person by doing something in return or by providing a counter promise. So in this way, the idea of contract is the fundamental underpinning for the idea of commerce and trade. So let's take the basic elements one at a time. First of all, offer. When the courts are asked to determine whether a contract exists or not, the first thing they look for is evidence that there was an offer. An offer is not the same as an invitation to treat, for example. An invitation to treat is a preliminary stage in negotiations which comes prior to an offer being made. So invitation to treat would be something like putting a price on goods for sale, or inviting contractors to tender for some construction work. These two examples are not offers, they're invitations to begin the process of getting offers from people so that we could form a contract. So an offer would be something where the other party could just say, yes, I'll accept your offer. That's the test. It doesn't necessarily lie with the buyer or with the seller. It just lies with the person who made the last statement before the acceptance was given. So the offer must be communicated, and only the person or the persons to whom it is offered can accept it. An offer can also be revoked, but only before it's accepted. So if a contractor puts in a price for some construction work, before the offer is accepted, the contractor could then revoke that offer and cancel it with no problem. But once the offer has been accepted, it cannot be revoked. It becomes binding. And of course, one response to an offer is a counter offer. So if I offer to do something for you in return for payment, you might make a counter offer, which is to say, well, yes, I want you to do it, but I don't want to pay that much money. That would be a counter offer, which I could then accept, or I could come back with another counter offer. So in the process of negotiating a business deal, there's often a series of offers and counter offers which come to an end when one of the party makes an unequivocal statement, yes, I accept that offer. So that acceptance must be unqualified. If it's qualified, it is a counter offer. So let's think about acceptance. Acceptance of an offer must be explicit. If it's vague, then it doesn't really count. The contract comes into being from the moment that the offer is accepted. Of course, having said that the offer must be explicit, having said that acceptance must be explicit, acceptance can come about simply by conduct. So if I order a lorry load of bricks of a certain specification for a particular price, that could be seen as an offer. If the brick supplier then delivers them to my place, that's seen as an acceptance of the offer. Other than acceptance by conduct, acceptances may be posted, they can be handed over in writing, or they could simply be oral. But however the acceptance is made, it must be communicated to the person who made the offer, not to somebody else. And typically, the acceptance relates only to the specific offer, with no implication as to future potential dealings. I mentioned earlier the idea of consideration. Consideration is the idea of some value being conveyed or some benefit from one person to another person. Normally this would be money, but the reason that the law uses the word consideration is that it takes into account those situations where the consideration is not money but some other benefit. There is a kind of contract that we will look at in later videos called a deed, which is typically a one-way contract that does not require consideration. But today I just want to focus upon the kind of contracts where there must be consideration. Simple contracts, the ordinary contracts that you would see every day. So consideration provides the basis of the agreement, and without consideration there cannot be an enforceable contract. In this way, the contract contains reciprocity in that each party provides something to the other. So, for example, a builder makes a building for a client and the client pays the builder for the building. So there's two-way benefits. Obviously, consideration must have some worth, but it does not necessarily have to be sufficient worth in English law, basically because of the principle of freedom of contract. In English law, the parties are free to choose the terms of their agreements, the terms of their contracts, even if those terms are uneconomic or imbalanced in some way. So, for example, in the transfer of property or the transfer of a business, you might not want a proper market price. You might just want to get rid of something and transfer ownership, in which case you could have consideration simply of £1. So we often see contracts where the consideration is only £1 and it's just a token to provide the basic mechanism of contract. There has to be an intention. A contract is legally binding, so clearly the parties must intend to be bound. If there's no intention, then there's no contract. So how do the courts tell when there is an intention? Well, first of all, the presumption of the courts is that the parties do intend to be bound. When there's a presumption in favour of intention, then it takes strong evidence to challenge that presumption. But one way of making sure that there's no intent to be bound when you're in the process of negotiation is to make sure that you write across the top of your documents subject to contract. That makes it clear to the courts that you're not intending to be bound by the things in that particular document. It's only later in the process that you might want to form a contract. And social or domestic arrangements are not usually intended to produce binding contracts, but sometimes they do, depending upon the actual circumstances. Then there's legality, which covers a range of issues. A contract has to be we have to be able to demonstrate that the contract is legal. So, for example, minors, children, who are not of legal age, people with mental disorders, or people who are drunk, inebriated in some way. If they sign contracts, then those contracts cannot be enforced. Obviously, somebody who's inebriated when they sign the contract could ratify it at a later date, but without such ratification, such a contract cannot be enforced in law. Similarly, with duress or coercion or threats, anybody who signs a contract under duress is safe in the knowledge that that contract cannot be enforced in court. And also, contracts have to have a scope that is within what is statutorily permissible. So you can't have a contract for commissioning a crime like theft or violence of some kind. If you try and have such a contract, it cannot be enforced in law. So any situation that doesn't meet these requirements of capacity, legality and so forth would be unenforceable in law. So, to summarise the situation, remember always that the purpose is to give effect to commercial activity. Firms and organisations are free to make contracts on whatever terms that they wish to make them. The contract comes about as a result of an offer, an acceptance which is clear and unequivocal, the intention to create legal relations, and legality of the subject of the contract. So that's a quick summary of the basis of the law of contract. I advise you to read a book about it and to check some of these facts and find some of the case law, but this is just intended to give you the bare bones so that you can continue with the study in your own time. Okay, thanks for watching. See you in the next video. Bye.